Hello, hello, hello. Welcome, everyone. Welcome back. Today, I am going to let you guys listen to the Northern District of Illinois transcript of proceedings before the Honorable Harry D. Linenweber. And this is for the Northern District of Illinois, the Eastern Division. And it is the pretrial services transcript from August 1st, 2019. And here we go.
1, 2, 3, 4, 4, 5, 1. In the United States District Court for the Northern District of Illinois Eastern Division United States of America, Plaintiff, v. Number 19 CR 00567-1, Robert Sylvester Kelly, Chicago, Illinois, July 16, 2019. Defendant. 1:02 p.m. Transcript of proceedings before the Honorable Harry D. Linenweber. Appearances, for the plaintiff, Hon. John R. Lausch Jr. United States Attorney B.Y., M.S. Angel Kroll, M.S. Abigail L. Paluzzo, M.S. Genus W., Appenting Assistant United States Attorneys 2. Case 1:1234562. Dwayne Morris, LLP by M.R. Christopher T. Groman 190, South LaSalle Street, Suite 3. Court Reporter, Judith A. Walsh, CSR. Case 1:19 CR 1234563. Proceedings heard in open court. The court, good afternoon. The clerk, good afternoon, Judge. 19 County Route 567, United States v. Kelly. The court, good afternoon. M.S. Kroll, good afternoon, Your Honor. Angel Kroll, Abigail Paluzzo, and Jean Nice Appenting on behalf of the United States. M.R. Greenberg, good morning, Your Honor. Steve Greenberg, Mike Leonard, and Chris Groman, who promises he's going to electronically file his appearance today. The court, all right. Mar Greenberg, on behalf of Mr. Kelly, who's present. Pretrial Services Officer, good afternoon, Your Honor. Jeffrey Arias on behalf of Pretrial Services. The court, okay. This is the defendant's petition for bond. Mar Greenberg, yes. The court, okay. The government has received the pretrial services report. I think I have two of them, one for the New York case and one for this case. And it's my understanding we've consolidated the matter for hearing today. Is that correct? M.S. Kroll, yes, Your Honor. Case 1:19 C. 1, 2, 3, 4. M.R. Greenberg, yes, Your Honor. The court, and it's my understanding that further that the government contends that some of the counts require the presumption of there are no conditions, which would then make the burden on the defendant. Do you agree with that, Mr. Greenberg? Mar Greenberg, I agree that some of the counts do, yes. The court, and how do you wish to proceed? If you let me ask this. Does the government intend to call live witnesses, or are you going to proffer, or what? M.S. Kroll, we do not intend to call live witnesses. We intend to proceed by proffer and a joint presentation on both cases. The court, all right. And do defendants intend to call any witnesses? M.R. Greenberg, no, Your Honor. We're going to rely on the recommendations of the pretrial services report and argument. The court, okay. And so the government then would proceed then. M.S. Kroll, thank you, Your Honor. Mar Greenberg, Your Honor, do you want us to stay? Here or? The court, well, probably seat. Kate, 1, 5. Mar Greenberg, thank you. The court, a proffer is not quite the same as testimony. Mar Greenberg, right. But I'm guessing it will be lengthy. The court, so there won't be cross-examination. Let me ask this. How long do you think the proceeding will take? M.S. Kroll, Your Honor, my argument is less than a half an hour long. The court, all right. Mar Greenberg, I'll be seated. The court, very good. Mar Greenberg, thank you. M.S. Kroll, thank you, Your Honor. The court, Ms. Kroll, you may proceed. Ms. Kroll, the defendant, Robert Sylvester Kelly, should be detained pending his trial because, first, he is an extreme danger to the community, especially to minor girls. Second, he poses a serious risk of obstruction of justice in his current case, which also makes him a danger to the community. And third, he poses a serious risk of flight now that he's facing more serious charges with mandatory prison time. In this case, as you noted, Your Honor, detention is presumed under the Bail Reform Act because the defendant is Case 1:1236 charged with producing child pornography, among other things. So detention, Your Honor, is our starting point, and it's the defendant's burden to rebut that presumption of detention, which it simply cannot do. The defendant here is charged with incredibly serious crimes involving the sexual abuse of young teen girls, some as young as being in middle school at the time. Middle school. We're talking 7th and 8th grade girls. And it didn't happen once or twice. He sexually abused them hundreds of times before they turned 18. And that's just 2 of the victims. Between the Illinois State Court charges, the case in the Eastern District of New York, and the case right here in the Northern District of Illinois, there are 12 unique victims identified in those cases, and the vast majority of them are minors. And that's just the tip of the iceberg. Our investigation has identified many more girls who were sexually abused by the defendant, and our investigation is far from over. The evidence against the defendant is overwhelming. It includes hard evidence, direct evidence in the form of 3 videos showing this man, Robert Kelly, sexually abusing a young girl who was only 14 years old at the time. These videos are extremely disturbing to watch, and they show defendant's sadomasochistic abuse of a 14-year-old girl. These videos also show defendant's particular sexual case 12347 interest in young girls because he repeatedly tells the girl to refer to her body parts, specifically her genitalia, as being only 14 years old. And he does so in such a way that shows his sexual interest to girls that particular age. The girl's age is repeated at least 15 times on this video, these videos, including by the defendant's own mouth. Also on these videos, the defendant makes the girl call him daddy over and over again. And there is no question that it is the defendant on these videos. There are extreme close-ups of the defendant's face on these videos. 2 of the videos are filmed in very distinctive rooms at his former home. And the victim in all 3 of these videos, she herself has testified under oath that it was Robert Kelly in all 3 videos sexually abusing her when she was 14 years old. There are at least 5 witnesses who will corroborate that victim. That evidence is overwhelming, Your Honor. The defendant repeatedly sexually abused a 14-year-old girl. He filmed it, and we have the videos to prove it. That weighs in favor of detention. But that's not all, Your Honor. In addition to the sexual abuse of at least 5 minors, several victims reported defendant's physical abuse in addition to the sexual abuse, hitting, slapping, punching, and spanking. And beyond the physical harm, there's the psychological harm that also must. Case 123-8. Be considered in determining whether the defendant is a danger to the community. Both the Illinois and the New York indictments list examples of the defendant's manipulative and controlling behaviors that impose lasting harm to the victims in cases like this. And that's particularly so when the defendant is not in custody, because these victims fear him. All of this makes the defendant a further danger to the community. But what sets this case apart from so many others and what makes the defendant even more of a danger to the community is the defendant's extensive history of obstruction of justice, the threats, the intimidation, the witness tampering, the hush money payments, all outlined in count 5 of the indictment. And these aren't just mere arguments from a prosecutor. This is what the defendant is actually charged with. A grand jury found probable cause that the defendant obstructed justice in all of those ways. This risk of obstruction is real. This risk is ongoing. And this risk of obstruction is heightened by the defendant's fame and power, which emboldens him to gives him a unique ability to influence and intimidate witnesses and victims, and that continues to this day. Now, I expect the defense will argue that the defendant should be released because this conduct is old and Case 1:19 129. Dates back to the 1990s. First, that's factually just not true. Count 5 of the indictment, the conspiracy to obstruct justice, that count alleges conduct right up to the present day. And the New York indictment includes conduct in 2015 against a minor and in 2018 against an adult victim. So it's just wrong to say that these cases deal only with old conduct. But second, and perhaps more importantly, so what? There is no statute of limitations for producing child pornography and enticing a minor to engage in sexual activity. If the defendant was sexually attracted to middle school girls, to 8th grade girls in 1999, then he is still attracted to middle school girls and 8th grade girls right here in the present. He sexually assaulted those girls hundreds of times. Being sexually attracted to young girls is not something that you can just turn on and turn off like a light switch. It hasn't just magically gone away. It's who the defendant is. It's what he's been doing for most of his adult life, and that, Your Honor, makes him a danger today. The defendant's team has also argued that these new federal charges in Illinois and in New York are just for the same conduct that the defendant was acquitted of in 2008. Again, not true. There are 13 counts in the Illinois indictment and 5 counts in the New York indictment. That's 18 total counts. Only one of those 18 total counts is the case 1-2-10. Same as his state court trial in 2008. That means that the defendant is facing 17 new criminal counts that he has never faced before. And what about that one count that does overlap with the old state case? That's count 1 of the Illinois indictment. The United States Department of Justice very deliberately charged count 1 of the indictment even though the defendant was acquitted of state charges based on the same conduct, and that's because the defendant obstructed justice and he ensured that the state trial was not a fair trial. He threatened and he intimidated minor one's family and other witnesses. He provided hush money payments and he manipulated and controlled minor victims into lying about their abuse. Charging this conduct in the Illinois indictment sends a message that no one is above the law, not even a famous musician with lots of money and power. Now, the defendant will say that he's not a flight risk because he has showed up to all of his court hearings in the past, but the stakes have significantly changed. He is now for the very first time facing a mandatory minimum of 10 years imprisonment and up to a maximum of 195 years on the Illinois indictment alone. On top of that, New York has a possible sentence of up to 80 years. And that changes everything. Case 1-11. And before last Thursday, the defendant faced only the same court system at the same courthouse where he illegally obtained an acquittal by obstructing justice, and he likely thought that he would do it again. Now he has federal charges. He had little incentive to flee then. Now he does. The very obstruction of justice that saved him last time is charged in this new indictment. And so he knows it won't work this time because this time, his victims are cooperating with law enforcement. And that, Your Honor, is his incentive to flee. There are no release conditions that can mitigate these dangers. Electronic monitoring and home incarceration are just insufficient here. Electronic monitoring does nothing about the obstruction of justice. It does nothing to prevent witness tampering. Defendant could easily obstruct justice from the comfort of his own home even if he has an ankle bracelet, but not so from the MCC where his communications will be monitored. And on top of that, the defendant can entice girls to his own doorstep. He doesn't have to leave his home to do that, especially when he has assistants and other workers who enable him as alleged in the New York racketeering charge. So electronic monitoring and home incarceration are insufficient to protect the public, to protect the victims, and to protect witnesses from defendant's obstruction of justice. Case 1-12. Finally, Your Honor, the defendant has already shown his intention to disrespect this court by not being fully upfront with pretrial services. When pretrial services asked him about his prior marriages, defendant conveniently left out his very first marriage in 1994, and that's because that marriage was to a minor girl who was only 15 years old at the time and the defendant was 27 years old. That marriage happened right here in the Northern District of Illinois, and the defendant knew that the girl was only 15 years old when he married her. Defendant was not upfront and truthful with pretrial services during his interview. Defendant mentioned only his second marriage, and he conveniently left out that first marriage because it incriminates him. He could have simply declined to answer that question if he didn't want to disclose it, but instead, he chose to lie and only talk about his second marriage. Mr. Greenberg, Judge, I'm sorry. I don't mean to interrupt, but I'm going to object to that. And maybe I'll be a witness. He did decline to answer the question. I was there. The court, that, I don't know. The record will be Mr. Greenberg, I the court, okay. You've established the record. 1 2 13. Whether that's true or not, I don't know. Ms. Kroll, all I know, Your Honor, is that's not reported in the pretrial services report that the government received, that it was a declination to talk about his first marriage. Your Honor, the defendant is a danger to the community. He is a risk of flight. And he poses a serious risk of obstruction of justice. For all of the reasons that I've just laid out, the government respectfully requests that this court detain the defendant pending his trial here in the Northern District of Illinois, and then also for any transport to New York to face the charges there. Thank you. The court, is New York going to make a presentation of its own? Ms. Kroll, no, Your Honor. They are not. The court, okay. So your presentation covers both, so Ms. Kroll, correct? The court, Mr. Greenberg. Mr. Greenberg, thank you, Your Honor. Your Honor, first of all, I just do want to address the pretrial services report. I sat in on the interview the other day, which is not something that we typically, I guess, do. But as I indicated in response when they asked about marriage, he declined to answer certain questions at my suggestion. Case 1-2-14. Beyond that, Judge, Mr. Kelly is 52 years old. He's been a lifelong resident essentially of Illinois except for brief stints in other jurisdictions. He lived in Miami when he was recording an album for a time. He lived in Atlanta for a couple of years. He lives here with 2 young ladies. In the media, they've referred to these ladies as somehow as hostages or slaves or whatever. They move freely about. They live their lives. It may not be how you or I or some other people may not choose to live with 2 girlfriends at the same time. That's how they choose to live. And, in fact, they're here in court today to support him. They're back here in the first row, Your Honor. So they're certainly not hostages. They're certainly not being held kidnapped. And that's sort of how this started. Late last year, when the father of one of them was claiming that he couldn't see his daughter, we set up numerous meetings since I've been involved with Mr. Kelly, and they've never shown up for those meetings. He has children. He's estranged from his children who live here. Even though he's estranged from his children, he pays child support every month. At one point, Judge, he fell behind on child support. He got jailed until he came up with the money. He came up with the money. He paid the child support. His child support is Case 1-2-3-15. Current and being paid. Even though he doesn't see his kids, even though his career is not what it was, he's still paying that. He doesn't travel. In connection with the Illinois proceedings, I turned in his passport. I looked at the passport before I turned it in. It was 7 or 8 years old. It didn't have a single stamp in it. He hadn't been anywhere, hasn't traveled around the United States for the last years. Every once in a while, he goes to play a concert somewhere and he'll travel to the concert. And I've said this before, unlike the song, his most famous song, which is, I Believe I Can Fly, Mr. Kelly doesn't fly. He doesn't like to fly. He drives to concerts unless it's somewhere he can't fly to. So, for instance, if he has a concert in California, he may have to take a plane. He gets medicated. He goes on the flight. That's one of the reasons he never travels to do concerts internationally, because he doesn't like to fly. He's got a van. He travels in his van. So he's not a risk to go to the airport and take off. And frankly, he would be recognized anyway. He's not going anywhere. He has no family or friends that reside outside the United States. He has no contact with people under 18. No one under 18 lives with him. No one under 18 lives around. 1, 2, 3, 16. Him. And they had to ask questions about internet and so forth. He has internet. He records on a computer. And he records. Obviously, you have to use the internet to do anything with the computer. And right now, Your Honor, he lives in a small, it's essentially a one-bedroom, I think they call it, plus den unit in Trump Tower on the 48th floor, a secure building, obviously. He lives there and he records there. He's taken the den. He's got some computer equipment in there, and with today's technology you can make a guitar and he can make keyboards and all of that, and that's what he does. And he basically stays in that unit unless he's walking his dog or going outside, as he likes to do from time to time, and smoking a cigar. He has no criminal record. And I'll get into the earlier case in a minute. But he has no criminal record. These are the third and fourth cases that Mr. Kelly has been charged with of real substance. Actually, they're the fourth and fifth. He got charged with a case in Florida. That was dismissed back when the other charges were pending here in Illinois back in 2002 to 2003. He had a case from 2002 to 2008. It was pending in state court here in Illinois. There were dozens of court dates, dozens upon dozens of court dates. He was required to appear, the best I've been able to determine, at each of those. Case 1, 2, 3, 17. Court dates. He appeared each of those court dates. He was facing extraordinarily serious charges at that time, Your Honor. The prosecutors maybe want to look down on the state court or the integrity of the state court proceedings. Those were extraordinarily serious. They were child pornography charges. He was facing, by my reading of the charges, possible consecutive time. And he went to trial on over 10 charges. He was looking at significant jail time. And he went to trial. He had to go to trial. I keep hearing this, you know, from the prosecution, and I see what they've done in their indictment. Obviously, I'm not privy to the evidence at this point, but they say that the case was somehow rigged. He went to trial. He wasn't, if it was he didn't take a bench trial. He had a jury. He didn't. No one says he paid off the jurors or anything. He had 12 people. Those 12 people watched the video in that case. The video in that case got played, the same video they're talking about here. The witness in that case that they've got here testified before the grand jury. Her parents testified before the grand jury back then that wasn't her. The jury heard all the evidence. The jury heard from other people. And the jury watched the video. And the jury acquitted Mr. Kelly. If the fix was in, he went through an awful lot, because the fix. Case 1, 2, 3, 18 was in. He was definitely at jeopardy in that case. Now, I don't know what their evidence is. I don't know what people who maybe knew Mr. Kelly was. He had fine attorneys. He had the Sam Adam, Jr. and Sr. He had Mr. Jensen on the case. I don't know what they're saying was going on with that case, because I haven't seen it. But Mr. Kelly had to go to trial. He had to face those jurors. He had to sit through a closing argument and a rebuttal closing argument where someone pointed their finger at him and said, based on the evidence here, we think you're guilty. They thought that they had presented enough evidence. If they had such problems with their evidence on that case, they wouldn't have gone to trial, the prosecutors. And I've talked to those prosecutors about that case. They certainly never suspected that anything was untoward in that case. He never missed a court date, never was late for a court date. Charged again here in Illinois this year. And again. They poo-pooed those charges. He's charged with Class X felonies here in Illinois and, again, facing potential consecutive time on Class X felonies. He showed up for court. The state indicted him. The state called me up. They said, we're going to add charges on the case. When do you want to come to court and be arraigned? We picked a date. He showed up. He showed up on time. He pled not guilty to those charges and the state. Case 123-19. Didn't even ask the judge to raise the bond on the case because there's no reason to believe that he is not going to show up. On the state case, judge, he posted $100,000. They had $25,000 he had to post, a $250,000 D bond on each of the 4 cases. So it's $100,000 total that's posted on that case. He's being monitored by pretrial services in the state court. They've never had a problem. They check on him. He does what he's supposed to do. They tell him to call, he calls when he's supposed to call. They tell him where to be, he's where he has to be. There's not any problem there. The fact that Mr. Kelly was getting charged in state court was no surprise to anyone. There was this, as they like to call it, documentary. I don't really think it was a documentary, but they call it that. And he gets charged. He turns himself in. They called me up. They said, hey, we charged this as original, not on the increased charges, the original charges. They called me up. We charged him with felonies. We'll give him 24 hours to turn himself in. We made arrangements, went to the police station, turned himself in, cooperated with them. They wanted to take a DNA sample. Sure, take the DNA sample, all that. He did that knowing that when I talked to the case 1:123:20 prosecutors about bond, they would not agree to a bond with me. So he did that full well knowing that he could be held without bond on the state charges. And had they called me on this and they knew I was representing him, had they called me on this, they wouldn't have had to pull up and arrest him walking his dog outside of Trump Tower. If they would have said, bring him in, we would have brought him in just like before. They argue that he's a flight risk when every single time, he has voluntarily appeared. He hasn't fled. He hasn't missed court. He hasn't been late for court. It was no secret he was under investigation here, Judge. It's been common knowledge he's under investigation here. He's under investigation in the Eastern District of New York. There may even be a second investigation in the Southern District of New York that I've heard about. It's a well-known fact. If Mr. Kelly was going to flee, he would have left. Then. He would have already left. He's not a flight risk at all. And I'm shocked that they even argue that they would even argue that. When they pulled up to arrest him on Wabash, he didn't try and run. He texted me shortly before. He saw the cars out there. I can show the government the text message. He saw the cars out that were out there, your case 123-21. Honor. He didn't go back into Trump Tower. He didn't go lock himself, he stood there smoking a cigar and walking his dog. He was polite. He was cooperative. There was absolutely no reason to believe that he would flee. How could he flee? He has no money. Mr. Kelly filed for bankruptcy 4-5 years ago. He doesn't, to the best of what I've been able to determine, own the royalties to his songs. Those were stolen from him. He would get small checks from time to time because, my understanding, I've learned a little about the business now. In this case, they don't make money from selling the music anymore because you can go on a streaming service, and the streaming service charges a small monthly fee. So the money's in concerts. And he doesn't play any concerts these days. He hasn't played any concerts for a while. So every once in a while, he'll get a check. It might be $30,000, $40,000. I think he got one that was a little bit bigger than that for royalty payments. He got a check. When I think it was Sony canceled his contract. There was an agreement as to how much it was. That money is gone. What did he do with that money? He didn't put the money when he got it. He got almost $400,000 right around the time of the state charges, I think right after the state charges. He didn't put that money in a safe in his house or in a hidden box somewhere. He put that money in a bank. Case 123-22. Account under his own name. And what happened? He had gotten evicted from his recording studio, and the people who evicted him seized the money in his bank account. And a big chunk of it went to pay because he owed back child support, so he paid it to back child support. And some of it went to pay his state court bond. And then there was nothing left. He prepaid his apartment. I believe it's paid for close to either until December or to January 1st in Trump Tower. He's prepaid that. And he has no other money to live on. He's got no money to flee on. He'll get a little check here and a little check there, and maybe some friends will help him. They say that he lives a lavish lifestyle, but he doesn't live a lavish lifestyle. They say that he faces a mandatory minimum sentence of 10 years now, so he's in some grave danger. He was facing a mandatory minimum sentence of 6 years before, and he was showing up. I don't see that as a sea change in what he's facing. They claim, Your Honor, that Mr. Kelly is a danger to minors. The way the indictment is written is very typical. It's vague as to what things are. And I understand why they write the indictments that way, but the dates are in there. So except for one allegation which I can't figure out what they're really saying in it, the allegations date back to the 90s. Case 1:19, 123, 23. Now, I understand statutes of limitations and all of that, but they date back to the 90s. They've been investigating him, state. They've been investigating him, federal. They've gone on TV and said, call us if you've had a problem with R. Kelly. They've gone on TV, other people, not the law enforcement, have said, we'll pay you for your story if something has happened with R. Kelly, yet we're still dating back 2 decades on allegations regarding minors except for one very vague thing that they've put in one of the indictments. There's no evidence that he's a risk to minors at all at this point. And they talk about the psychological risk or something like that. I don't know what that is, but whatever it is, detaining Mr. Kelly isn't going to fix someone if someone's got some kind of psychological issues because of something happening to them. Those aren't connected at all. In fact, the only proof here is that he isn't a danger to minors. The fact that it's been 2 decades since there were these allegations shows that he isn't. They say that he's a danger because he's going to obstruct justice in this case just like he did before. And I don't have whatever their evidence is, but I can tell you a little bit. And these are not secrets. This is well known about Mr. Kelly and Mr. Kelly's business. Mr. Kelly had a case 124 business manager. He had a lawyer. He had an accountant. He had people who worked for him, other people working for him, all of whom have a lot of money now. All of them have a lot of money now, but Mr. Kelly doesn't. He doesn't have any money. It's not a secret that Mr. Kelly doesn't read. He doesn't write. Now, if other people did something when he was facing trial before because they wanted to protect, the money tree, I don't know about that, and I haven't seen the evidence on that, but he wasn't doing it. He wasn't doing it. And let me tell you why, even if the government says he's a danger because of the obstruction charges, why their argument impeaches itself. He's charged in that count with 2 other people, Daryl McDavid, and everyone has always told me Daryl McDavid was the guy who ran it, he was the business guy, he was the accountant, but he was the business guy, he was the guy who handled all Mr. Kelly's affairs, and a guy named June Brown. The government agreed to recognizance bonds for Daryl McDavid and June Brown. June Brown, I think, turned himself in Las Vegas. My understanding is he got a recognizance bond. Daryl McDavid turned himself in here and got a recognizance bond, but he's charged with obstruction. If obstruction is such a danger and such a risk to everybody. Case 1:19 CR 00567 document hashtag 54-1 filed, August 1st, 19 page 24 of 40 page ID hashtag 224. 1 2 3 4 5 6 7 8 9 10 11 25. Then why did the government agree to a recognizance bond for Daryl McDavid? And I'm sure they've got their reasons, but it certainly shows that charge doesn't imply that anyone's a danger. Frankly, Mr. Kelly, well, there's no evidence, Your Honor, at this point, and there's no evidence because it hasn't happened that since Mr. Kelly has heard these rumors swirling around which have been around now for probably a year and a half, 2 years about criminal charges and so forth, that he's done anything to any witness, to anyone he thinks might be a witness, taken any action at all. There's no suggestion that since the state court charges were filed that Mr. Kelly has done anything wrong at all, anything. Hasn't talked to a witness. Hasn't interfered with a witness. And I don't even think that was a condition of his state court bond. Was that a condition, Steve, that he not have contact with anyone? Was it a condition? Okay. It's a condition of his bond that he's complied with that. But he complied with it before it was a condition of his bond. He didn't do anything. Now, they say that all of this is different and all of it is different charges, different victims and all that. We respectfully disagree, Your Honor. We think that there is great overlap. And we think that some of the cases in case 1, 2, 3, 4, 5, 26. Fact, overreaching. For instance, where they've got predicate acts in a RICO prosecution because you could have transmitted a sexually transmitted disease in violation of state law, they're making it into a RICO case. I know they've got other allegations, but they've got things like that in their case. We think that it's terrible overreaching. We think that they're trying to criticize how consenting adults who never complained for years and years all of a sudden say, oh, no, I didn't want to be in that kind of a relationship. There was something about that relationship. These people who are their witnesses have been on a greatest hits tour since this first hit. They've been on TV. They went to the awards in Las Vegas, the MTV Awards, and got an award for the documentary. They went to some other award show and we've got this, they tweet and they video and oh, this is great. My mom has never been the one. Girl who is charged, she's one of the people in the state. Case. My mommy's never been to anything like this. I'm so happy I got to bring my mother to this. I mean, give me a break. That's what this has turned into. They've got in here that he was forcing people to do labor. I have no idea what they're talking about. Was he forcing a girl to collect tickets? Was he forcing her to record? What is it? It's so vague, we can't respond, we can't attack it, but we're going to attack it. Case 1, 2, 3, 27. Mr. Kelly's conditions, Judge, another factor I think the court can take into consideration. He is in the SHU, which is the Special Housing Unit. He's in the SHU because, frankly, for the MCC or any other institution, Mr. Kelly is a difficult prisoner to have there because of other prisoners, not because of anything Mr. Kelly is going to do but because of his notoriety. Mr. Kelly, there's going to be an enormous amount of discovery in this case. He can't read and he can't write. Someone's going to have to sit down with him hour after hour after hour, day after day, and go through the discovery. That's virtually impossible to do if he's in custody. In the SHU, he gets 15 minutes a week to speak on the phone, not like other inmates. There's no day room. There's no television because that's normally the hole. That's where they take people who are in trouble. There's no television there. And he can't read, so there's no books to read. There's no anything. So he literally sits there in isolation. All day long. And if we go to meet with him, the attorneys on the case, we went over there yesterday. What would you guys say? The room is 6 by 8? Probably a 6 foot by 8 foot room, and we're all crammed in there. That's the room that we have to meet with him, and they have to shut everything else down while we do. Case 1, 2, 28. They have to shut everything else down while we do it. Now, whatever you may think of the charges, whatever the government may think or the public may think of the charges, the man's going to have to prepare for trial, and the man's entitled to be held in a humane situation. We have reviewed all of the conditions listed in the pretrial services report. He doesn't have a passport. That's been taken by the state. We have no objection to any of the conditions that are listed in the report. And we believe that it's perfectly appropriate in this case that he should be allowed to return home, whether it's on electronic monitoring or home detention or whatever, though I know there's various levels of federal detention when you're kept at home, but that is, in fact, appropriate, commensurate with the presumption of innocence and the proper bail that should be set in this case. May I have one moment, Judge? The court, yes, sir. Pause. Laura Greenberg and Mr. Groman has pointed out to me also that they executed a search warrant on Mr. Kelly's residence after he was arrested. I believe that I read somewhere they found 2 bullets, I think, which were in a cup with change. He had weapons. Those were all turned into the state when he was arrested on the state charges. Those were Case 1:19 CR 00567 document hashtag 54-1 filed, August 1st, 19 page 28 of 40 page ID hashtag 224. 1 2 3 4 5 6 7 8 9 10 11 12 13 14 15 16 17 18 19 20 21 22 23 24 25 29. Probably buried under the change. But they found nothing that I'm aware of during that search. The court, thank you. Mar Greenberg, thank you. The court, Ms. Krall? MS Krall, thank you, Your Honor. I just briefly want to address a couple of the things raised by Mr. Greenberg. First of all, Mr. Greenberg raised the fact that Mr. Kelly's co-defendants were released on bond. And yes, that is true, and here's why. There are 0 allegations against Mr. McDavid and Mr. Brown that they have ever sexually abused a minor. They are not charged in the most serious counts in this indictment, and they are not charged with counts that carry that presumption of detention. And second of all, with respect to the charges relating to the obstruction of justice, Mr. Kelly was the leader of that conspiracy to obstruct justice. And whatever his co-defendants did in furtherance of that obstruction of justice, they did at his behalf. And I want to make clear, with respect to the count of receiving child pornography, that conspiracy to receive child pornography that both McDavid and Mr. Brown is charged in, their role in receiving that child pornography was not because they enjoyed viewing child pornography. It was Case 1:19 CR 0056 123 30. Because the defendant instructed them to obtain these sex tapes with minors that the defendant was on. And so it's not like they had an interest in minors. They were doing what the defendant told them to do. That's why they're charged in that count. And so we did not seek detention for those individuals because we did not see them as the extreme danger to minors that the defendant is. The other thing I'd like to mention, Your Honor, is that throughout Mr. Greenberg's presentation here, he never once mentioned minor 1. He never once mentioned the strength of our evidence regarding Mr. Kelly's sexual interest in middle school kids. He never once mentioned that she has now gone on record that, yes, that is her on 3 videos. And I want to emphasize, it's not just the same video from 2008. We have 3 videos showing the defendant sexually abusing minor 1. And the other 2 videos were not part of that 2008 trial. So these charges are much more severe than what he was facing before. And the other thing I'd like to say, Mr. Greenberg liked to focus on a lot of the adult victims in the case, and he was not focusing on the minors. And I'd like to make clear that the 8th graders that I mentioned, including minor 1, never have they appeared before a TV camera. Never have they been seeking fame and fortune. They have cooperated with the United States government because we Case 12331 reached out to them. They are not on TV seeking money from the defendant. That's all, Your Honor. The court, anything further? Mr. Greenberg, no, Your Honor. The court, all right. Under the law, the specific charge of child pornography, creating and possessing child pornography, does require a presumption of detention that there are no conditions that would be sufficient. And it would be up to the defendant to demonstrate that they're to get away from this presumption. And I do not believe, based on the allegations that have of the indictment which bear the imprimatur of the grand jury, which means that the grand jury, after hearing evidence certainly produced by the government, found probable cause for guilt of all of the specific counts in both the indictment here in Chicago and the indictment from New York, in the Eastern District of New York. The charges are extraordinarily serious. The 1. Specific 1, count 1, 2, and 3 carry a mandatory 10-year penalty, which is a very which indicates how serious those specific charges are, and, in addition, they carry the detention presumption. As far as the obstruction of justice, according to the specific count in the indictment that the case 1:19 CR 00567 document hashtag 54-1 filed August 1st, 19 page 31 of 40 page ID 12332. Acquittal was at least in some part obtained because of obstruction of justice, which involved allegedly paying off of witnesses and threatening witnesses and buying back certain evidence in the forms of the videos that, even though apparently there was one that was played, there were several other videos. And if all 3 videos or 4 videos, one of which apparently has not surfaced yet but must be out there somewhere, had all 3 of them, who knows how the case could have come out. Supposedly, according to the indictment again, I go by the fact that a grand jury found that there's probable cause that witnesses were paid and witnesses were threatened in order to either change testimony or not appear at all. So it appears to me that the defendant has failed to overcome the presumption of requiring detention in both the case here in Chicago and the case in New York. Although, does the presumption apply in the New York case? MS Kroll: yes, it does, Your Honor. The court: all right. So the presumption in both cases, that there are no conditions that will assure the defendant's attendance at trial and no conditions that will protect the public and certain individuals. Accordingly, the court denies the motion for bond. Thank you. Case 1:1234533. MS Kroll: Your Honor, I believe that we also have to take care of the defendant's arraignment. He was unable to be arraigned the very first day that he was arrested. The court: all right. Mr. Greenberg, has the defendant received a copy of the indictment? Mr. Greenberg: he has, Your Honor. The court: have you advised that he can't read it, but have you read it to him? Mr. Greenberg: we've gone over the charges with him, yes. We'll enter pleas of not guilty, and we'll waive formal reading. The court: all right. Would the government put on the record the maximum penalties? MS Kroll: yes, Your Honor. For counts 1 through 4 of the indictment, the maximum possible penalties are 20 years imprisonment with a mandatory minimum of 10 years, supervised release of not more than 5 years, a fine of up to $250,000, and a special assessment of $100 along with restitution. With respect to count 5, the conspiracy to obstruct justice, the maximum term of imprisonment is 5 years. Supervised release of not more than 3 years, a fine of up to $250,000, and a special assessment of $100. With respect to count 6, conspiracy to receive child pornography, and also count 7 and 8, the actual receipt of case 12334. Child pornography, there's a mandatory minimum of 5 years imprisonment on each of those counts, a statutory maximum sentence of 20 years on each count, supervised release of at least 5 years and up to lifetime supervised release, a fine of up to $250,000, and a special assessment of $100. And finally, with respect to counts 9 through 13, enticement of minors to engage in criminal sexual activity, there's a statutory maximum of 10 years imprisonment on each count, up to 5 years of supervised release, a fine of up to $250,000, a special assessment of $100, and also restitution. The court: he's been arraigned on the New York charges already. MS Kroll: yes, he has. The court: all right. Mr. Kelly, your attorney, I understand that he tells me that you cannot read. And so do you feel that you understand the nature of the charges of the indictment? The defendant: yes, sir. The court: okay. All right. The court accepts. Let the record show that the defendant, case 1:19 1 2 3 4 5 6 7 8 9 10 11 12 13 35. Guilty. The rule as far as discovery is concerned, the government will proceed immediately to furnish discovery, is that correct? MS Kroll: your Honor, we were going to ask for some time to be able to work out a protective order with all 3 defendants because a lot of the materials that we'll be producing involve minors. And we are working on a protective order before we produce anything. So we would like maybe an extension of a week to your normal schedule for the Rule 16 conference. The court: is that acceptable? Mr. Greenberg: I don't know what a week means. Give me a day that they're talking about. The court, are you talking about 2 weeks for the production? MS Crawl, right. Normally, we get 2 weeks to produce the Rule 16 materials. We're asking for an extra week because Mr. Brown's not even in town yet. We're not sure of his attorney situation, and we'd like to produce to work out this protective order with all 3 defendants in the case before we produce anything. The court, so you want 3 weeks to produce? MS Crawl, correct. Mar Greenberg, Judge, given that Mr. Kelly is going. Case 1:19 CR 00567 document hashtag 54-1 filed, August 1st, 19 page 35 of 40 page ID hashtag 224. 1 2 3 4 5 6 7 8 36. To be in custody, we can look over whatever they propose as a protective order, and it will be binding on us. And if they want to work out another protective order, what happens if Mr. Brown gets here and says he needs time to find counsel? I don't want to be at Mr. Brown, who is out, his leisure. The court, well, we're talking about 3 weeks maximum. Now, if they can't work out a protective order, he doesn't get counsel in time, they will proceed with discovery MS Crawl, correct? The court, within after 3 weeks even though they have not. So they would have to do it piecemeal, I guess, too. Is that acceptable? I guess the question is? Mar Greenberg, I'm not trying to be difficult. The court, no, I am Mar Greenberg, but how difficult is it to do a protective order? The protective order is going to say, don't show it to anyone other than the lawyers. The court, I don't know. Mar Greenberg, and people working on the case. The court, I don't know. Mar Greenberg, it seems pretty simple. I would think they've got one on their word processor. The court, normally, you'd think it might be simple. 1 2 3 4 37. But then I've been here long enough to know that that isn't always the case, that people come up with objections. I guess I repeat the question, you object to 3 weeks. Mar Greenberg, I do. The court, all right. I'll make it 2 weeks. Let's see. What else do we need to do? Discovery in 2 weeks. Do you wish to file pretrial motions? Mar Greenberg, I'm sure we will. The court, how much time? Would you like to do it now, or do you want to look at them, and then we can have AMR Greenberg, I'd like to look at the discovery. The court, all right. Why don't we do this? We'll come back in 30 days and we'll set a schedule for motions. And is there objection to excluding time? MR Greenberg, no, Your Honor. The court, all right. To the next status will be 30 days after you get the discovery. The clerk, September 4th at 10 o'clock a.m. The court, September 4th. The time will be excluded without objection to September 4th for the purpose of the interest of justice and in the interest of justice. And for pretrial motions which counsel advises that there definitely will be. So okay, without objection, time will be. Case 1:19 CR 00567 document hashtag 54-1 filed, August 1st, 19 page 37 of 40 page ID hashtag 224. 1 2 3 4 5 6 7 8 9 10 11 38. So excluded. MS Crawl, thank you. The court, September 4th at 9 o'clock. Mar Greenberg, thank you. The court, anything MR Greenberg, what about MS Crawl? Your Honor, I imagine that New York is going to want to have an arraignment in New York on their charges. The court, hasn't he been arraigned? I thought you said he MS Crawl, I misspoke earlier. He had his initial appearance on the removal proceedings, but he needs to be arraigned before the court. Oh. MS Crawl, the district judge there. And so I do believe, though, September 4th should give us enough time for him to have his appearance there and be brought back to Chicago for your September 4th date. I'll work with the marshals on that to make sure that that's okay. The court, all right. MS Crawl, but it sounds like it should be enough time to get him to New York and back. Mar Greenberg, which is a whole another complication, Judge. Case 1 2 3 4 39. The court, are you representing him in the New York case? Mar Greenberg, we very well may be, but he has a lawyer there. The court, does he have one there? Amar Greenberg, right. Because I'm not licensed. The court, all right. Well, Ms. Kroll, we can also talk about video conferencing with New York to see if that is a possibility. The court, all right. Work that out. Mar Greenberg, we can't arraign him here now. We've reviewed those charges with him also, but the court, I don't know. Ms. Kroll, he's entitled to appear before the district judge there. The court, well, is that a waivable? Ms. Kroll, I can work on that to see if that's acceptable to the judge in New York and the prosecutors in New York. The court, all right. If you want to arraign him in front of me on the New York charges, then just schedule it with the clerk, and we can do that. Ms. Kroll, thank you, Judge. I'll work on that. Mar Greenberg, thank you. Case 1:19 CR 012340. The court, anything further? Mr. Greenberg, no, Your Honor. Ms. Kroll, no, Your Honor. The court, all right. Will stand adjourned. The clerk, all rise. Proceedings adjourned at 1:56 p.m. Asterisk 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 CERTIFICATEI Judith A. Walsh do hereby certify that the foregoing is a complete, true, and accurate transcript of the proceedings had in the above entitled case before the Honorable Harry D. Lanenweber, one of the judges of said court, at Chicago, Illinois, on July 16, 2019,